I'm Spencer Mazik, and joining me now is Joshua Rosenkrantz. He's the head of Oryx Supreme Court and Appellate Litigation Practice, who recently obtained a landmark victory on behalf of his client, Supark Kirtsong, in a case where the U.S. Supreme Court ruled that publishers and manufacturers can't block imports of copyrighted items legally made and sold abroad, sustaining a multi-billion-dollar gray market. Welcome, Josh. Thank you for joining us today.
Thank you, Spencer. Good to be here.
So before we get to the court's rationale for the ruling, which many people are calling a victory for all American consumers and businesses, can you remind us, though, first of what was at issue in this case?
Sure. I mean, an issue in this case really was a 400-year-old principle that boils down to when you buy it, you own it. When we buy anything, any product, we assume we have the right to lend it, to sell it, all the way down the stream of commerce. And there was this question in copyright law. For about 30 years, courts had been holding that there's an exception for copyrighted goods that were made abroad. And so that's why the gray market implications were so huge. There is an enormous market for goods that are imported into the United States. About $63 billion worth of products get imported into the United States. And it's not just books or CDs that have copyright protection. Anything with a label, anything with instructions, anything with computer software. So the stakes were enormous.
So was the issue trying to reconcile these two distinct parts of the Copyright Act, the first sale doctrine with the copyright owner's importation rights?
Exactly. And there are two provisions in the copyright law that seem to clash directly with one another. There's the first sale doctrine, which says, as I said, if you buy it, you own it, for any product that is lawfully made under this title, was the catch language. And then there's another provision that says that copyright owners have the right to block importation. So the question becomes, which of those two provisions prevails?
Well, and this wasn't the court's first encounter with these two sections in the same case. There was the 1998 Quality King case, and most recently, the 2010 Costco versus Omega. So wasn't the issue here squarely raised in Costco?
It was raised first in Quality King, as you mentioned. We thought it was resolved there, but courts have since said no, Quality King was good for that case only. And then it was raised in Costco and not resolved because the court split 4-4.
With Justice Kagan recusing herself, right?
Exactly, and she recused herself because as Solicitor General in that very case, she had filed a brief against our position. So this was one of these cases where all the betting money was against us. Why would Justice Kagan reverse what she told the Supreme Court as Solicitor General was the correct position?
Right. Well, and she didn't recuse herself this time around, joining the majority in a 6-3 decision in favor of your client. So what was the court's rationale here?
Well, what the court said was that the first sale doctrine has been around for 400 years, as I mentioned earlier. It's been kind of a steadfast right of anyone who buys products. And the language of the Copyright Act, that first sale provision, doesn't say lawfully made in the United States. It's not unique only to U.S.-made goods. It also applies to goods made abroad. And the court also really took a page out of our briefs and a lot of the amicus briefs and kind of followed through all of the very mischievous consequences that would arise if you read the first sale doctrine to be limited only to products that were made in the United States.
Well, and you're right. Justice Breyer said that the statute says nothing about geography. But, you know, it's pretty common for publishers to have this price discrimination scheme to price copyrighted works on a per-nation basis. So do you think that's going to change now in light of this case?
I don't think it'll change very much. I mean, you put your finger on what the stakes were for the publishers. The publishers are very accustomed to charging one price in foreign countries and, quite frankly, gouging U.S. customers who can afford a higher price. And what people like my clients did, or Costco, or Target, or Walmart do constantly is arbitrage. They do what people have been doing for hundreds of years. You buy it where it's low, where the price is low, and sell it at a price that's below the high price that consumers here are being gouged at, but still higher than the price at which you bought it.
But so you don't think we're going to see a one-price-fits-all scenario?
I don't think so, because there are still transaction costs to importing goods. I do think it'll change practices. I think what will happen is there will be stricter contracting provisions as to who exactly can be sold to. But my client was this graduate student who was from Thailand and just had his family ship books over, textbooks over to the U.S., and he sold them on eBay and made a little bit of a profit. I think those practices will continue.
Well, so had the court gone the other way and ruled in favor of Wiley & Sons, what would that have done to, as you mentioned, the $63 billion gray market?
Well, it would have been devastating to companies like eBay that really do not verify the origins of their products when the products are being sold on eBay. It would have been devastating to those low-cost retailers like Costco and Wal-Mart. It really would have increased prices here in the U.S.
Well, and Josh, I know that you've won the case, obviously, but would you agree that Congress's poor statutory drafting here could support two different but equally plausible interpretations of the act here, yours and the plaintiffs?
So I confessed to the Supreme Court that there were two plausible interpretations. Our argument was that our interpretation is better, slightly better. I mean, that it's a fairer reading of the statutory language. And the problem is the two provisions are in such tension with one another that there's very little light between the two of them. And trying to explain to the court why our interpretation could prevail even and still give meaning to the other provision was a real challenge.
Well, so do you think, I think Justice Kagan mentioned in her concurring opinion that Congress is free to change the law if it feels that copyright holders need more protection. Do you think it will?
No. Everyone knew going into the Supreme Court argument that the Supreme Court was going to be the decision maker because there are such powerful interests on both sides. They will certainly try. Publishers have done this before. I mean, they do have a powerful lobby, but so do the retailers now. There was a day, maybe 30 years ago, when the publishers really did have their run of Congress on issues of copyright law. I think those days have long since passed. And it's so much easier to kill a bill than it is to pass one.
So tell me this then, will your client Kurtzong continue importing and selling copies of Wiley & Sons books online?
No. He's done with that.
He's done. This is the end, huh?
That was just his way of making a little extra money while he was in graduate school. He's now back in Thailand teaching students, which was part of the condition on the scholarship that he received to come to the United States.
All right. Well, in your opinion, then, what's the significance of this case?
I think it just, the significance is huge as an economic force. I mean, there is this enormous market that we've already talked about. It has other ramifications. There were very mischievous consequences of Wiley's interpretation. So, for example, if lawfully made in the United States, lawfully made under this title means only made in the United States, then it affects all sorts of copyright rights,
Absolutely.
Such as the right of a book of a bookseller to resell books. That's the easy one. So
libraries,
thrift shops, libraries, because it's about possession. So lending out books, Netflix, and what we kind of rolled out to the court, and Justice Breyer picked up on, even any piece of electronics has copyrighted software in it. And if the owner of that copyright gets to control downstream sales, you're talking about cars with navigation systems being controlled by the copyright owner, that is sales of them downstream. You're talking about any camera that is marketed in the United States. And so the potential ramifications were even bigger than that gray market question.
Which is why, as I mentioned earlier, many have said that this was a victory for all American consumers and businesses. But I believe that you've actually argued 8 cases in the last 6 years before the Supreme Court. So can you tell us, how did this case come to you?
Well, we look for interesting cases. And this was a case where, interestingly, there wasn't a direct circuit conflict. So every court of appeals that had decided this issue had come down against us. But there were kind of tensions between the Second and the Ninth Circuit, which is based in New York and San Francisco, respectively, and the Third Circuit, which 2 decades ago had suggested that it agreed with our reading of the statute. The court had split 4-4 on it, so this was an obvious choice for the court to try to resolve the controversy. And so we just reached out to the lawyer who had litigated the case at the trial level and said, would you like some assistance in this? We'd love to help you.
Well, I'm sure he's glad he did.
Well, it was a great collaborative relationship.
Well, thank you so much for joining us here today. We hope to have you back at some point in the future on another case.
Great, Spencer. Good, glad to be here.
For more information on this or other topics, subscribe to BloombergLaw.com. You can follow us on Facebook and Twitter. Thank you for joining us. Bye, everybody. Thanks.